The Appellate Division First Department is now in session. Good afternoon, everyone. Welcome to the Appellate Division's virtual argument. We are about to begin, and I'm going to start by calling the calendar. People versus Jonathan Thenn for the appellant.
On behalf of Mr. Thenn, Molly Schindler with the Center for Appellate Litigation. Good afternoon.
Good afternoon. 4-1, Ms. Schindler.
Thank you.
For the respondent.
Good afternoon, Your Honor. Megan McLaughlin for the people.
4 minutes. Good afternoon. Squitieri versus Kaufman is submitted. BNB Bank versus Health First is submitted. Rodriguez versus 352-54 West 48th Street for the appellant.
Good afternoon, Your Honor. Jonathan Landsman for the appellant.
Good afternoon. 5-1. For the
Thank you.
respondent.
Good afternoon, Your Honor. Jackie Aiello from Boyd Richards for the respondent.
Good afternoon. 5 minutes. Judge Mendez is recused from this case. Judge Weber is vouched in. So unfortunately, to avoid any technical issues, I have to call your case at the end of the calendar. Okay. People versus Nathan Johnson is submitted. Lorelei Financing versus Merrill Lynch for the appellant.
James Rigger of Meister Seelig.
6-1 for the respondent.
Yes, Roger Cooper for the respondent.
6 minutes. Edelman Arts versus New York Art is submitted. People versus Khalil Galloway for the appellant.
For the appellant, Hannah Gladstein. Good afternoon.
Good afternoon. That's 4-1. For the respondent.
Good afternoon, Justice Renwick. John Hughes for the people.
Good afternoon, Mr. Hughes. 4 minutes.
Thank you.
You're welcome. Cressa versus 345 Park Avenue is submitted. Zanani versus Sutton Apartments for the appellant.
Yaron Zanati for the appellant. Pro se. And the
That is, yes, 6-2. And for the respondent.
Good afternoon, Your Honor. Jay Berg for the respondent.
That's 5 minutes.
Thank you.
You're welcome. Galsch versus Diefenbach PLLC is submitted. Gateway Overseas versus Sumac Tiles for the appellant.
Good afternoon, Your Honors. Ira Tokayer for the appellant.
That's 5-1. Good afternoon. For the respondent.
Good afternoon, Your Honors. This is Hui Liu for the respondent, Sumac. Thank you. Good afternoon.
Good afternoon. That's 5 minutes. Mellon versus Mellon is submitted. Yes Contracting versus CLST Enterprises is submitted. Sudban Robeson versus Robeson is for the appellant.
Jason Advocate of Advocate LLP. Good afternoon.
Good afternoon. That's 4-1 for the respondent.
Jonathan Robson, acting pro se. Good afternoon.
Good afternoon. Counsel, please remember, as always, that we have your briefs, we have your record. We are fully familiar with the facts of your case, so please go directly to the most important points that you wish to make. Also, as is customary, please don't speak while a justice is speaking. This, of course, is particularly important during our virtual session so that we can ensure that you hear the question that's being asked. And finally, please keep your mics muted unless you are the person speaking. And as always, we thank you for your patience and your cooperation. The first case for argument is People versus Thenn.
Good afternoon, Your Honors. May it please the court, Molly Schindler on behalf of Mr. Thenn. Mr. Thenn's situation is unique, and not just for the severity of his offenses, which is unique, but also because of the exceptional risk reduction that he achieved during his prison sentence and in his treatment program that was measured by a number of measures that are both objective and subjective. There was an individual expert evaluation concluding that he was at no more than average risk of reoffense. There was a risk assessment instrument conducted by his treatment providers that is expressly designed to measure the progress in treatment and a reduction between the beginning and the end of treatment that goes into great detail about the reason for that reduction. On that instrument, Mr. Then was found to have achieved the highest level of reduction that the instrument even measures. And then there's also a number of subjective measures, descriptions from his treatment providers about his progress in treatment, about his exemplary conduct is the word that they repeatedly use throughout his records.
Counsel, this is Justice Moulton. I'm sorry to interrupt you. One thing he invokes is his closeness with his family, but I didn't, unlike Davis, the case that you cite, I didn't see how the family support was anchored to his rehabilitation.
Your Honor, family support is it's a factor that he did not have in the same sense that he currently has. So it reduces his risk, or at least serves as a protective factor in his case, because it serves as a contrast between his life at the time that he committed his offenses and his life now. When he committed his offenses, he was 19 years old at the beginning, 21 by the end, and he had isolated himself from his family in the most emotional of senses. He had not disclosed or even grappled with sexual abuse that he himself had undergone as a child, and repeated experiences that he had had where he was, as a minor, abused by older men, and even his own sexuality was something he had not disclosed to his family. So he was very isolated from his family and from the community. Whereas going through treatment and going through even mental health, individual mental health counseling for years before he was offered the treatment program, allowed him to not just deal with those experiences, but also open up to his family. And you can see from the letters that his family wrote to the SORA court and the letter from Mr. Then to the SORA court, the level of support that they offer him is really exceptional. His mother actually moved apartments just so that he could have the benefit of living with her instead of in a homeless shelter, despite the housing restrictions. And I did want to mention about the housing restrictions, because this was a misstatement in my in the respondent's brief. He will have the housing restrictions regardless of his level. Because of the age of his victims, he is subject to those restrictions for the duration of his 10-year PRS term, whether he's a level 1, 2, or 3. So he will not be able to live within 1,000 feet of children. And of course, because of his record and his registry status, he's not going to have nearly the same access to children that he had in his previous career. That's something that's being closely monitored. But even aside from that, the evidence in the record shows that he is not at a high risk anymore, even if he had that access, because of the incredible progress that he made in treatment. He is absolutely a success story. And he is that rare case where someone can show by a mere preponderance that they have performed exceptionally in treatment and reduced their risk. He exemplifies why a SORA hearing is conducted not at the time of sentencing, the time of somebody's release to the community, because it's not just about the crimes that someone committed and the harm that would be caused. It's about the risk that would be, the risk that the person poses to the community. And we ask the court to grant a downward departure because the evidence shows that that risk is significantly reduced.
I'm assuming that's your bell because I don't have one.
You did, yeah.
And your time is up indeed. Okay, thank you. Ms. McLaughlin, I think it is.
Yes, Your Honor. May it please the court. I just wanted to first and foremost address or respond to the argument regarding defendant's response to sex offender treatment while in prison. Despite the fact that defendant has not shown that his response was exceptional, as the guidelines put it, even an exceptional response to treatment does not automatically indicate that the defendant is at a lower risk to reoffend. The guidelines provide that an exceptional response may be grounds for a downward departure, but that response still needs to be taken in context with all of the other details surrounding defendant's crimes under Galati. And here, the defendant in this case sexually abused 6 young boys while working as their babysitter, employed by families who trusted him.
Well, of course, that's what counsel was referring to when she says that's why the SORA hearing is not had at the time that the person commits the offense. So we know the offense, and we know that he spent 10 years in jail, and he has his 10 years of PRS. The question is, given factors that exist now, given the treatment, training, counseling, recommendations from his psychologist or psychologist, I'm not sure, can't recall which one it is, and family support and all of that, some of which indicate exceptional participation and results. Why isn't that enough for a departure here? I mean, why aren't they, although they might have been factors, why aren't they mitigating factors that weren't taken into consideration to a kind or to a degree?
Your Honor, there was no reason at the time of the hearing to believe that defendant had done anything during his prison treatment that would indicate that he was no longer a risk level 3. While he made commendable progress during his treatment, and no one will deny that, he did not do anything that would lower his level in the people's position to a level 2 risk level. And through all of his evaluations, there's nothing to indicate that he went from a high risk to a moderate risk. He may have gone from an extraordinarily high risk to a high risk, but there's nothing to indicate that this defendant is not at a high risk of reoffending. And as the RAI points out, his risk of reoffending is not only high, but the guidelines also take into consideration the harm that would occur if the defendant were to reoffend, which in this case is very clearly significant. He subjected numerous children to sexual abuse, and he did so in a calculated manner. He intentionally surrounded himself or put himself in a position to be around children. And while his risk may have in some level lessened during his time in treatment, it's still high, and regardless of its height, the harm that would occur if he did reoffend is so extraordinarily high. And that is something the RAI takes into account in his score that something like the static 99 does not. And that is, again, why the RAI is a much better measure and why the SORA court depended on that score, because it takes into account the amount of victims and the type and nature of the abuse that this defendant inflicted on all of these children.
Thank you. I don't know if you have a bell, but your time is up as well. Okay. You're welcome. We're back to Ms. Schindler.
Thank you, Your Honor. We're outside of the RAI at this point because this is a downward departure analysis, and there are actually numerous measures that show that provide indications that the people said are lacking, that he's no longer at high risk. There's an individual expert evaluation concluding he is not at high risk. And there is the information from the VRSSO, which is that risk assessment tool I mentioned, conducted by his treatment providers. And I would ask Your Honors if, in the record, the narrative that goes along with the VRSSO is one of the most crucial pieces of the record, in my opinion. And it's in Exhibit A, at the very end of Exhibit A of the defense affirmation in this case that was submitted below, because it goes into detail about exactly why and how Mr. Then's risk is reduced from what it was at the time of his offenses and at the beginning of treatment, and exactly what are his risk factors that heightened his risk, and how has he addressed them? How has he achieved this really extraordinary reduction in his risk? And this is so extraordinary that Mr. Then does present one of those rare cases in which a downward departure in the exercise of this course, independent discretion, is warranted. Thank you, Your Honors.
Thank you. Thank you both. The next case for argument is Lorelei versus Merrill Lynch.
Thank you, Your Honor. This is James Ringer for the plaintiff appellate. The main issues in this case.
Mr. Ringer, if I could start with a question.
Oh, I'm sorry. Yeah, of course.
Quite all right. Supreme Court said, I'm curious about your loss. Supreme Court said that your loss was caused by nothing more than the intervening event of the crash, the financial crisis in 2008. And then you say that there was no intervening crash because your loss was from 2006, the time that the Auriga was purchased. But in 2014, you argued, your Lorelei argued before this court on a motion to dismiss, and they were successful in that regard, that the loss that you suffered was in 2008 at the earliest. It was either at the event of default, which would have been in February of that year, or it was at the time Auriga was liquidated, the shares were liquidated, securities were liquidated. So doesn't that now preclude you? Aren't you judicially estopped from arguing that your loss was the time in 2006 when you purchased the securities?
No, Your Honor, it does not, because as we pointed in our brief, there were two different issues here. The issue in the earlier appeal had to do with when the loss was realized or discovered, which would have started the statute of limitations running. That did occur at a later date, but the loss had already taken place. As we point out, and our experts point out, had the information about Magnetar been disclosed, the rating agencies would have assigned a lower rating at the time of issuance. A lower rating necessarily would mean a higher interest rate to compensate for the risk. In this case, the pricing information shows it would have been 3 to 7 times higher. So from that moment on, we suffered a loss in the income stream that we should have received but didn't. The fact that we didn't discover it till later is not relevant.
I don't quite see how, because I think the loss that you're talking about goes to loss causation. So I don't quite see how that changes, because in the one you were talking about the starting of the statute of limitations and the other you weren't. But it seems that the loss has to be the same for loss causation. And this is two different events, 2 years apart. But
I would respectfully disagree, because the issue in the context of statute of limitations runs from the discovery of the loss, which in fraud cases is often years later that the loss is actually discovered. That doesn't change.
Let me ask you this. Let's put that aside for a minute. Let's say you're not judicially estopped, unless someone else, another member of the panel, has a question about the judicial estoppel. But your theory of overpayment on the day of the loss still doesn't eliminate the loss causation. So how do you prove not only that the defendant's misrepresentation caused you to buy Auriga at this higher price, but also that their fraud caused the eventual price decline?
There are two different issues there, Your Honor. The overpricing or the overrating. Remember, the defendant specifically represented in the offering that these notes would have AAA and AA ratings. They didn't. Our expert speaks to that. That loss, the loss that stems from a higher risk, is independent of what happens later. The value of those notes was immediately diminished. The fact that there may have been some
this is Judge Gish. Can I just stop you there for a minute? Yeah. So were you arguing to us that this is a different theory of damages, a more traditional theory of damages than we have under basis PAC RIM, which involves loss causation? Are you arguing something different?
I don't think so, Your Honor. It's the same issue. In basis PAC RIM, the question was the loss caused by the fraud or something
you acknowledge, else? So let me stop you there. So you acknowledge you would need to prove loss causation, correct?
Yes, and I believe
in order to recover damages. All right, so now let me take you a step further. Judge Maisley below, she said you didn't have the data to prove loss causation. What she said is you didn't create an issue of fact because you didn't have your expert compare the Constellation CDOs with other like CDOs that were available in the marketplace to show that the loss was greater in the Constellation CDOs than it was just generally from the market loss, from the market failure. Is that true?
No, Your Honor, the truth is.
So where is that data? Where would we find it?
You're looking at the wrong thing. The data is that when the bonds were sold, they were overpriced. We paid too much to get the return.
But that's something different, all right? That's a different theory of recovery, I think. But is there data of the kind that Judge Maisley was looking for? Is it there? It may not be there. You may not think it's relevant, but I just need to know. Was she right? That data is not there.
She was wrong in the sense that the data that she refers to came from the defendant's expert, which was flawed. And we point out that he compared the Origa with a hypothetical portfolio, which he comprised, which excluded 20%.
Again, I'm going to ask you to answer my question. Did you put in any data of the nature that she was talking about, where you compared the Constellation CDOs with other like CDOs available in the marketplace to compare their relative failure rates? Is that in your expert's report? And that I would think is a yes or no. It may turn out that you're right, it's irrelevant, but I just need to know if she were right, if she was right in her assessment of the record.
She was correct that our expert did not focus on the comparison. What he compared was the risk profiles of the Origa notes and whether or not they matched what they were represented to be. And that necessarily impacted what we would receive. Had the notes been rated properly, we would have received triple the interest, maybe more. That effectively we didn't get, and we suffered that loss. And that caused the value of the investment to be cut in half or more. The fact that the financial crisis may have wiped out what was left doesn't impact the fact that we had already suffered a loss.
Can I ask you, in the expert's report, he says Magnetar deals experienced events of defaults on average approximately 4 months faster than other mezzanine CDO bonds issued in 2006 and 2007. What was he comparing that to then?
He was comparing it to the universe of CDOs issued at the time. By looking at them, he saw that the Magnetar CDOs had suffered an event of default and therefore liquidation on average 4 months sooner. And that's in his report.
And then, okay, thank you.
Yeah, if you'd like, I can continue on.
Yes, you should continue. If you have other points to make, you should.
Well, I have many points to make, I think, but I think the issue of reliance is also important here. I think by definition there was reliance. Justice Masley acknowledged that what she called transaction causation, but transaction causation definitely requires reliance as well. And here, our clients relied upon the information they were provided and that they would generate and would have reasonable expectations that they would receive legitimate AAA and AA ratings. The fact is they didn't. Had the information been disclosed, and it wasn't. And there was nothing that IKB could have disclosed that would change that because they were never told. And in that sense, it's sort of like the Tyndall case. The ratings would have been lower. We would have received a much higher interest rate. The value of the bonds on that moment was diminished by, a calculation which our expert tries to show was at least 25, maybe 75 or more %. And that loss already had taken place. And it is just as Judge Calabrese says in the Lincoln House example, if you pay a premium for something and it's based on something that's false, that premium is gone. It doesn't matter that a flood happens later and wipes out what's left. The fact is the defendants defrauded us. they misled us as a result of their fraud. We suffered a loss of what we should have received, which was namely higher interest, higher ratings.
So I just want to go back to the expert a minute, and because I want to, are you saying that your expert within this comparison that you just said with other CDOs at that point is sufficient to make out the case for the Auriga?
Yes, I think it is, but I think the primary point he makes is that we had already lost half of our investment, even before you start figuring out what the default rates were. But he does point out in his report that the Constellation CDOs did default faster than the other universe.
I think he says all 26 mezzanine Constellation deals experienced an event of default. The Auriga ones were faster than, I think they were 175 days earlier than the average.
I believe he does, but I think he also points out that all of the Constellation CDOs, in comparison to the universe of other CDOs, experienced earlier rates of default. It wasn't just Auriga. The Magnetar involvement caused all of them. And Auriga is the example that we deal with because that's the one we bought. So.
Yeah. Sorry to interrupt you. Go ahead.
Okay.
I've let you go on quite long because we interrupted you. So if you could just wrap up.
I would wrap up.
Rebuttal.
I think I have rebuttal, and I think everything we say is in our briefs. But I think the key factor here is they concealed information that negatively affected the ratings. That caused a loss that very moment.
Thank you. Mr. Cooper, is it? I'm sorry.
That's correct, Your Honor. Good afternoon. Yes, it's Roger Cooper from Cleary Gottlieb on behalf of the Merrill Lynch respondents. Thank you. So the trial court correctly granted defendant's summary judgment on two independent grounds. First, on loss causation, as Your Honors, I think, have just recognized in the questions, plaintiffs presented no evidence countering defendants showing that the financial crisis caused plaintiffs' 2008 economic loss when the Auriga CDO defaulted.
Well, what about plaintiff's expert? I mean, why isn't the information that was presented by plaintiff's expert showing these comparisons of the Magnetar deals and the Auriga? Why isn't that enough?
So, Your Honor, I think what Mr. Ringer said muddied the record here, but below and on their papers here on this appeal, they do not argue that their expert presented any evidence or that they presented any evidence to show that the loss in 2008 was caused by the false or misleading statements that they allege. They argue they do not have to. And so there may be some stray points in their expert's report on this issue, but it's not systematically developed, and they have not argued that in either below or here. Instead, what they argue, Your Honor, is that they're entitled to make use of this overpayment theory, right? That on the day of the purchase, their loss was caused by the misleading statements, and that as a result, they overpaid on that very day. As Your Honor recognized, that theory is inconsistent with what they have said to this court back in 2011 in sworn filings, when they said specifically that they did not suffer a loss.
This is Judge Gish. Assume for a minute that it wasn't inconsistent, that was just for discovery of the statute of limitations purposes. Is there another reason why we wouldn't look to that as a possible damage formula for a common law fraud?
Absolutely, Your Honor. So first, I think basis pac rim is clear that that the plaintiff needs to separately prove each element: loss causation, transaction causation, and damages. Each must be proven separately. And in basis pac rim, the plaintiff failed to do that, didn't present any evidence whatsoever to counter the defendant's prima facie showing that the loss during the financial crisis was because of the widespread market collapse. That's what caused the CDO to lose value. Court granted summary judgment. Defendants did the same thing here. And the best that plaintiffs came up with was evidence that Justice Maisley said amounts to transaction causation. The same thing. They focused on the time of the transaction in 2006 and not the loss in 2008. The only case that they try to rely on is the decision in the Second Circuit, Allegheny. That case is irrelevant. They call it their time purchase loss causation theory, but it simply doesn't exist under New York law for securities. Allegheny itself says that it only applies to the sale of a business where the asset has intrinsic value because of intrinsic qualities of that asset, and there the court focused on key personnel. There are other courts that in a few instances have applied this, again focusing on the sale of a business and intrinsic qualities of that business. But Allegheny then goes on to say expressly that it doesn't apply to an investment in a security. And the court says there is a presumption that the shares are purchased for the purpose of investment. And therefore the value depends on the future performance of those securities. There's no doubt, there's no question, right, that the CDO here is a security. In basis pac rim, obviously this court previously treated the CDO there as a security. And basis pac rim relies on the Second Circuit's decision in Lentel. And Lentel was also faced with this very argument about the purchase time disparity. And Lentel said that's not enough because that theory merely explains why an investment was made, that is transaction causation. It does not speak to the relationship between the alleged fraud and the investment loss.
Well, I'm curious if, for example, there's judicial estoppel here, and they're stopped from arguing the 2006 loss, and they have to argue the 2008 loss. Does that change what you've said?
No, well, Your Honor, we think that both of those are reasons why Justice Maisley was correct in granting summary judgment. First, they have to demonstrate that the loss causation with respect to the 2008 loss because they're stopped from arguing anything else. But even if that were not the case, there's no legal basis for arguing that their 2006 time of purchase loss causation is enough because every court that has considered that argument that we are aware of has rejected it. And there's no authority that they point to whatsoever to support that argument. And the best that they have is Allegheny. And I think you can see they try to bring in sort of other arguments to support this, recognizing the challenges. And
Counsel, this is Justice Moulton. Sorry to interrupt you, but can we draw the inference for summary judgment purposes that all CDOs are not created equal? I think we can all agree on that. And that a CDO that's created by a net short investor, I know you slightly disagree with that, but they have some allegations about that, will be a CDO that will underperform for long investors. And so that provides a sufficient evidence of, possible inference that this CDO, you also have to show reliance on facts that were not disclosed, but that gives us some inference of loss causation.
I don't think so, Your Honor. Here, the case is so close to basis pac rim, and we have that analysis to follow. And just as here, there, the case involved a common law fraud claim. The allegations there as here are that there were misrepresentations about the riskiness of the CDO. Now, maybe they say that that has to do with Magnetar and this short selling, but it boils down to the same thing. And then you have the financial crisis, which is what is the cause, the defendants in both cases say the cause of what resulted in the actual loss. And in both instances, the plaintiffs did not come forward with any evidence whatsoever countering the defendant's prima facie showing that it didn't matter what happened. It didn't matter whether there were misrepresentations because that CDO would have failed, would have lost its value anyway. And if their theory is correct, right, that really the fraud is what was the cause of their loss, they are obligated to show that link, to demonstrate with some evidence that the misrepresentations are what caused the risk, misrepresentations over the riskiness are what caused the loss in 2008. And they haven't done that at all. I think I may be running out of time. I do want to say—
You have run out of time, but I'll give you 30 seconds to wrap up. Go ahead.
Yeah, very quickly. So we don't think there's any authority whatsoever on loss causation. On reliance, we'll rest on our papers. Happy to answer any questions. But there, as Justice Maisley correctly found, there's no evidence on reliance that the plaintiff relied on any direct or indirect representations from the defendants. Also, in addition, that there's no evidence that defendants intended to induce reliance. There are pages 55, 56 of our brief. But finally, plaintiff in their papers for the first time on appeal raised an agency theory. It wasn't raised below. It should be rejected. And we go through in our papers the reasons also why there's no support for it, even if you were to consider it. But with that, we request that the court affirm summary judgment. Thank you very much.
Thank you. Thank you, Mr. Cooper. Okay, Mr. Ringer, you have a minute.
Thank you, Your Honor. I'll try to be very brief. We cover this stuff in our brief, but we, in fact, did counter the defendant's expert. We showed that a loss had occurred on the day we purchased because the ratings were incorrect and we didn't get the proper interest rate. And more in the same fashion, defendants their expert, they don't offer anything to contest that. Their expert said, I didn't even look at that. The fact that the assets of the CDO did have intrinsic value, and just like a business, you can purchase the business through buying shares or buying assets. The fact that it was a security doesn't change it. And as far as Mr. Cooper's statement that every court has rejected this analysis of time of purchase loss, that simply isn't true. We compiled the cases in our briefs, and I won't try to waste time explaining those, but they are set forth. The reliance is clear. We relied upon the fact that we were being told things that we weren't told. IKB couldn't tell us something that they weren't told, and that the rating agencies weren't told, all of which led to higher ratings, greater risk. Greater risk translates into a loss.
Thank you.
Thank you.
Thank you both. Thank you both. People versus Khalil Galloway.
Yes. Good afternoon. May it please the court. Hannah Gladstein for the appellant, Mr. Galloway. Mr. Galloway fled his mental health treatment program because he was suffering terrifying, irrational psychiatric symptoms. And this was only 2 days in before he had even had the opportunity to engage with his treatment program. He spent the next 4 months in and out of psychiatric hospitalizations, paranoid, hallucinating, and not compliant with his medication.
Counsel, the question is whether or not he had whether the court needed to make any additional findings or have a hearing or something to that effect after he came back and before the court then sentenced him to the 5 years. And it seems like, it was pretty clear based on Mr. Galloway's own statements that he had absconded, that he apologized before it in the court. He said that he messed up. So it doesn't seem that there was, I'm not sure if that was his language, but I think he said that he failed to complete the program and comply with the opportunities, and that was unfortunate, and he apologized for hurting the victim. So what was left for the court to discover on the that issue?
Well, that was Mr. Galloway's statement at the time of sentence, at the point at which it had become clear that he was not going to be given another opportunity at treatment. But there was a lot of advocacy done by his defense counsel in between in an effort to secure an additional chance at treatment for Mr. Galloway. Defense counsel presented—
I understand that. What you're saying is the court could have given him another opportunity, used its discretion to give him another opportunity, but that's discretionary, isn't it?
Well, I think that, it's our position that the court was on notice because of the very abundant evidence presented to the court regarding the circumstances under which Mr. Galloway left treatment, that perhaps this was not a situation where he left treatment for reasons entirely within his own control, to use the language that this court has used previously in Rivera, that this was not a willful departure because it was something that he did in reaction to completely irrational psychiatric symptoms, he was hearing voices telling him that he was going to be killed if he stayed. And so the record before Justice Wiley would have put him on notice that as the person responsible for supervision of the plea bargain, that before he imposed sentence, he did need to conduct an inquiry. And it didn't have to be a full-blown hearing. Fiametta makes that clear, but he needed to conduct an inquiry, and he needed to state on the record what his inquiry consisted of, what his findings were, and the basis for those findings. And that is what he didn't do, and that is what we are asking this court to remand for, so that that inquiry can be made, because the evidence before the court below was quite compelling that this was not somebody who just ran away for, because he didn't like treatment. He hadn't even had the opportunity to engage in treatment. And as to that, I do want to...
Just, I'm sorry, wasn't that information before the court? Wasn't the court aware of the reason that he had left? Didn't he say that he thought people were attacking him? Or I can't recall exactly, but something like to that effect. I mean, wasn't
what he said, what defense counsel said in his submission was that Mr. Galloway had told his medical providers and then him that he left because he was in the waiting room awaiting his first psychiatric evaluation and was hearing voices telling him he would be killed. And so he left. And these are exactly the symptoms that had convinced everybody.
Isn't that exactly what the court heard and knew? Didn't the court take that? In other words, it would remand, those facts were already available to the court. The court was aware of those facts and, exercised its discretion in denying it.
Well, I think we cannot infer from a silent record what the court considered. The court simply didn't say anything. The prosecution indicated that they were not willing to consider another opportunity at treatment. And from there, Justice Wiley never made any findings of his own. He never said anything. He just, it seems that he assented to what the people wanted to do, but I hesitate to even say that because my contention is simply that we cannot infer from the silent record. And I did just want to say,
I have a question though, but wasn't it incumbent on the defense attorney to ask for the Outley hearing? He made the facts known that he thought would compel a more equitable decision in favor of his client, but there was no request for a hearing about disputed facts, were there?
He didn't. No, he did not explicitly request a hearing.
And did the people say, no, don't believe this guy, it's not true?
The people never said anything. The people
never said anything, right?
Yeah, the people came back to court and said, we're not willing to do this. And from there, it just sort of proceeded. There was a 7:30 exam in the middle, but from there, it just proceeded to sentence. There was conversation about, in that case, what is the sentence going to be on the new bail jumping indictment? But the people never took a position. The people now are saying, well, you can't believe that because of what he subsequently said in his pre-sentence report. But no such argument was made below.
Not at the time. Right. I mean, nobody said to the judge, gee, don't believe this stuff and don't consider it.
No, and I think that that's what an inquiry would have surfaced. Like, what did Justice Wiley find credible? What did he not find credible? Was there additional information he wanted? And I really do. I want to draw the court's attention to a document that we just made part of the judgment roll last week. It's the letter that the cases program provided to Justice Wiley to inform him when Mr. Galloway fled from the program. And that letter is interesting because what it says is that the ACT team was going to continue searching for him in an effort to re-engage him in treatment. So he had not actually been kicked out of the program. At that time, the program was still willing to work with him. So then 4 months later, when he came back after this long stint in hospitalization, an inquiry would have also allowed defense counsel or the program an opportunity to talk about whether the program was still available, which it seems that there's a good chance it might be. And that letter also makes clear that Mr. Galloway left while in the waiting room awaiting his initial psychiatric evaluation.
Let me just ask you something. I'm sorry, but now Mr. Galloway is on, has been released. He's on his pre-sentence term, serving his pre-sentence term. Am I right?
Post-release supervision, yes.
Post-release supervision, right. So what would the remand achieve at this point?
So if upon remand, after the inquiry, Justice Wiley agreed that, a number of years ago before serving a prison sentence, Mr. Galloway should have been given the opportunity to do treatment. Having already served his sentence, obviously it would be difficult to restart treatment. But this was a plea agreement that contemplated, upon successful completion of the program, dismissal of all of the B and C felonies. And at that point, perhaps there would be an agreement that dismissal of the B and C felonies would be appropriate in light of the fact that rather than receiving the treatment that he really sorely needed, he had to endure 5 years of incarceration plus a number of years of post-release supervision. I do want to say that even if the court, Justice Gish asked about whether there had been a request for a hearing, and while there was not, if the court is inclined to find that this is unpreserved, I do want to emphasize that there is a very ample record before this court that defense counsel made that would enable this court to exercise its interests of justice jurisdiction. And I think that given the very long prison term that he ended up serving, having committed no new crime except for, missing a court date, and given the extent of his need and his, the fact that he really did not get any opportunity to engage with treatment, interest of justice jurisdiction is appropriate. And in the alternative, we are asking this court to reduce his term of post-release supervision from 3 years to the minimum of 2.5.
Thank you. Mr. Hughes?
Yes, good afternoon, Your Honors. John Hughes for the people. What this case really boils down to is that below, defendant never actually disputed that he had violated the plea agreement. And it's our position that this case essentially ends there. First of all, because that means that defendant's current appellate claims are unpreserved, but it also means that really the court didn't have any obligation to, conduct a more thorough outlet inquiry of any kind, because again, there's really no issue before it about whether or not, the defendant had actually complied with his plea agreement. Now, of course, we don't dispute that, the defendant has experienced mental health issues, and, we don't dispute the defense counsel, mentioned some mitigating circumstances below, but that was really pretty explicitly in service of a request for discretionary leniency. And, if you look at defense counsel's comments on April 6th, for example, defense counsel is saying, I'd like to try to convince the prosecutor to give him another chance at treatment. And also, if you look at just defense counsel's comments, the people's comments in response to that, it's pretty clear that really no one there understood defendant to actually be raising a claim that, he was entitled to specific performance of the plea agreement at that point. And that's really what, the appellate issue on this point really comes down to. With that,
I don't think that he was I don't think they're suggesting he was entitled, but that the court, had he, taken everything into consideration, could have exercised his discretion to allow him to go back to the program, rather than, as is sometimes done, rather than immediately, resort to the incarceratory period.
Well, I think for the discretionary question, I believe the people would have had to agree for, the second chance of treatment. However, if defendant had actually made an argument like, hey, I didn't actually violate the plea agreement, I should get specific performance of this, then in that case, yes, the judge would have had an obligation to, at least make an inquiry and then, rule on the issue about, whether or not there was actually a violation of the plea agreement. But again, here we think that, defense counsel's comments were, really, again, just asking for discretionary leniency. And also, as Your Honors already pointed out, too, I would note the defendant is already serving his post-release supervision term, and I believe he has only a little bit more than a year left at this point. If Your Honors don't have any other questions, then I'll rest on our brief and ask that you affirm. Thank you very much.
Thank you. Ms. Goldstein, we're back to you. Gladstone.
Yeah. I do want to say, the prosecution would have had to consent to another chance at treatment. However, the court always has an obligation in its supervisory role over the plea bargain to ensure that the sentence is fair. And the record before the court the defense counsel was very clear that what he was asking for was for continued treatment. And that triggered the court's obligation to conduct an inquiry and ensure that the sentence was fair before it was imposed. And again, if the court is not inclined to find preservation, it's a very, very rich record that defense counsel developed regarding the circumstances under which Mr. Galloway left, and that it was not willful. And if the court is not inclined to find preservation, this court can exercise its interest of justice jurisdiction, either to vacate the plea and send it back, or to reduce the sentence by, the 6 months of post-release supervision over the minimum that he received.
Thank you. Thank you both. Zanani versus Sutton Apartments.
Yes. Good afternoon, Your Honors. My name is Daron Zanani. I hope you can hear me.
Yes, I can.
The appellant on this case. This is an appeal, actually, which considers 3 different papers. The original motion, the original order to dismiss my complaint. Then there was an amended order granting attorney's fees to the co-op defendant, and then a judgment of the actual attorney's fees. And I'm going to actually argue in reverse. I think regardless of the merits of my complaint, based on the actual court's decision the first time around, that the court was entitled to attorney's fees only to the extent of the subject proprietary release, they're not entitled to attorney's fees, because the proprietary release at issue only allows attorney's fees if I am in default, and there has been actually no default by me. I just started a lawsuit for declaratory judgment, and this court on 3 different occasions has held that a shareholder who litigates with a co-op, when there's no pending default, neither side obviously gets attorney's fees. The only breach or alleged default that's in the picture relates to the civil court eviction proceeding, which, even setting aside the appellate term order granting me serving judgment dismissing the petition, that alleged breach was admittedly cured in June of 2018, which was really 7 months before I started this lawsuit. So even assuming I'm in default by not replacing the bank check that the government agency lost, the court is still not entitled to attorney's fees. So I think however the court decides the underlying issue of the complaint, the judgment has to be vacated. With respect to the merits of my complaint with the 3 causes of action, the court can either rely on the appellate term order, which ultimately dismissed the petition and granted me summary judgment and held that I'm entitled to attorney's fees, and the court was not entitled to any relief, including interest, late fees, use of competency, whatever else they were asking for. Or if you want to go, one by one, the first 2 claims relate to the fact that for some bizarre reason, even though the government agency lost the check, they were still charging the co-op interest. And following that, the co-op decided that I should pay that interest. And they did not cite any clause in my lease or any statute or any case law where if I deliver a check to the payee and the payee loses it, the one who delivers the check is the one who has to continue paying interest. That would make, I think, credit card companies very happy. And if that's the case, then they clearly are not entitled to collect attorney's fees or late fees or any other charges relating to the fact that I'm not paying the interest on the co-op's payment to this agency. With respect to the 3rd cause of action, the co-op did not deposit 5 of my checks. They acknowledged getting it. They didn't return it. They didn't give it back. And, so I stopped payment on those 5 checks, and I then sent a later check. And then they claimed they didn't get it. And then I went through the same routine. They didn't get it, but they don't want to give me an affidavit, and they want to charge me late fees and claim that I'm in default. So that's the reason I started this lawsuit. And at a bare minimum, I think there are issues of fact as to whether or not the co-op's interpretation of their right to charge me this interest for this agency, or to hold me in default, even though they refused to give me an affidavit that they lost a check, which I was willing to replace, and which I did in the reply papers.
Can I stop you? This is Judge Gish for just a minute. Sure. Didn't the appellate term appeal take care of at least the first 2 issues that are raised in this declaratory judgment?
I made that clear in my brief, which is why I'm not elaborating.
Right. So if that's the case, Was the judge wrong in saying that the holdover was another action pending in which the issues between the parties, the disputed issues, were being adjudicated?
No, because Judge Banger's ruling at that time was before the appellate term order. So there was a hearing for the co-op's attorney's fees.
But the holdover had been pending, though.
Well, to the extent that there was going to be a hearing for attorney's fees.
I just want to ask, did Justice Moulton want to ask a question?
No.
Okay, sorry. The blue
Did I
circle
raise my
going
hand
on.
or something?
And the circle keeps lighting up. Okay, I'm sorry, Mr. Zanani.
No,
was
that's
that-
the extent of my argument.
Okay, thank you very much.
Very simple. Thank you. Thank
Yep.
you.
Yep, Mr. Berg?
Thank you very much, Your Honor. Can you hear me? I just.
Yes.
Great, thank you, thank you. May it please the court. Back when I started writing appeals and arguing these things in 1993.
We don't want to go back that far, but
You don't. Okay.
why don't we just get right to the facts here?
One of the first things I
Issues,
learned.
not the facts.
Okay. The argument that he's raising now, that he wasn't in breach of the lease, was not raised in the court below.
Well, let's just ask this. His check was lost, is that right?
That is correct.
Okay. I just wanted to clarify, and then he was charged interest. I know that there's this question about the prior pending action, but ultimately the appellate term reversed the lower court in all respects.
That's
right?
correct.
Why don't you pick up, right, why don't you pick up from there? And he started the other action. Obviously, that was before the appellate term had resolved, but we have the resolution now. Where do we go from here? Do you suggest?
What I suggest is that you affirm the order of the Supreme Court, and the reason being is that he didn't replace that check till very, very late in the proceeding. While there was
but this check is the check we're talking about that the appellate term already decided about, right?
That's correct. But the appellate term didn't decide that at the time that the judge on this case was deciding the motion, and the judge who decided.
Let me stop you there, though. The motion that was before this court was to dismiss because there was another action pending.
That is correct.
Right. So that it didn't matter who was ultimately going to prevail. The concept of another action pending is that there are overlapping issues, and there's an inefficiency to letting two courts decide the same issues, regardless of who wins, regardless of who's right. Correct?
Correct.
You agree with that? So on some level, it doesn't really matter that the trial court decision at the time the motion was made was decided in your favor, and it doesn't really matter that it was reversed in terms of whether another action was pending, correct?
Correct.
All right. But there was one issue in this case that I quite frankly don't understand as an overlapping issue, and that concerned the 5 maintenance payments, correct?
That is correct.
That wasn't the issue in the holdover proceeding, was it?
I don't think so. I don't think that was.
No, I don't think so either. So if that's the case, shouldn't this proceeding have gone forward?
I don't think so. And the reason being is because this was basically at heart a collateral attack on the civil court judgment. And the civil court was deciding all of these issues, including the issue of use and occupancy and whether he owed any or not.
Well, use and occupancy is different than maintenance from a legal point of view, isn't it?
Yes.
Right. Use and occupancy is something that the court awards when there no longer is any kind of landlord-tenant relationship. The proprietary lease has already been deemed terminated.
Mm-hmm.
So it really doesn't impact on the issue of whether the lease should have been terminated because he didn't pay 5 months maintenance, which in fact it seems like he did.
No, he didn't pay 5 months maintenance. He claims he did, and he claims that they lost the check. He doesn't, he presents absolutely no evidence that he even sent the check to the managing agent other than the cover letter.
Okay, I'm going to allow that for a moment. And assuming that's true, that could not have been litigated in the holdover proceeding. You were seeking UNO because you had terminated the lease based on his default and not paying the $122,000.
That's
right?
correct.
Okay.
Your time is up. I'll give you some time to wrap up, Mr. Berg.
Thank
And
you.
you don't have to use my offer, but if you want to.
Yeah, I think that the award of attorney's fees should stand, and I think that the dismissal of the case should stand. There was no need for this case. There really wasn't. He could have argued all of these things back in the civil court if he had wanted to. He chose to come to the Supreme Court. He's an attorney. He used his skills as an advocate, and he's not to basically cost my client, the co-op, money to oppose these things. There isn't any reason why he shouldn't have to pay the money that we had to, our attorney's fees are having to fend against this case when the whole thing could have been resolved. He could have resolved this much earlier had he.
Mr. Berg, I just have a question.
Sure.
So you're saying that it's Mr. Zanani's fault for not having sent the money in. He says he sent the money in and that your client lost the check and all he asked for was for an affidavit. And, you know, like you're saying that he could have settled it. You could have provided him with that affidavit. And then he would have sent you another check.
He wanted an affidavit stating that they lost it. They never even got it.
But if that's all it took for him to send you another check, and you would have, you know, saved yourself a lot of grief and a lot of attorney's time spent, and maybe we wouldn't even be here. Why wasn't that done? I mean, it was simple. A simple letter, fine. Send me the check, I'll give you an affidavit. That whatever check you sent before, although we never got it, you know, we lost it. That's it. End of story. So now you're saying it's his fault. He never sent the check.
He wanted an affidavit from our managing agent stating that our managing agent lost the check. That's what he wanted.
I think we've got your point.
Okay.
Thank you.
Okay.
Mr. Zanani, we're back to you.
Yeah, okay, so just want to clarify 3 points. One is that the co-op never asked for use and occupancy in the holdover proceeding. That was never an issue. They never made any request or application, had no idea that's what they wanted. This is something that they make. If you look at the record, there's nothing in the record about this. But all they did was they got my checks, they wouldn't deposit it, they wouldn't return it, and I had no idea why. Number 2, this preclusion argument. And the reason I didn't argue in the court below about the fact that there was no breach to support attorney's fees, is the court never made that argument. All they asked for was sanctions. Pages 30 to 34 on the record, Jennifer Powers asked for sanctions against me under Rule 130. That's their entitlement. That wasn't granted. There was nothing in her 25-page affidavit asking for as an attorney's fees because I committed some kind of breach. So that's the reason I didn't make a counter argument, which is why I believe I'm not precluded on this appeal to say so. And of course, it's compounded by the fact that Judge Bannon gave him the right for the fee application, but apparently didn't give me the right to oppose it. So I sent her a letter and she didn't want to do it. So I'm sort of like, you're doing this for the first time, unfortunately. The last argument dealing with the affidavit, I don't know if it's in the record or not, but my request was that to say that for them to tell me that they either lost it or didn't get it. I didn't care. As long as they said, you know, we don't have it, we're not deposited, I'll replace the check. I'm a shareholder. I know
they won't cash it.
Yes, and that would have been fine with me.
I think we understand.
And that's it. That's it, Your Honor. Thank you very much.
Thank you both.
And by the way, I'm not asking for attorney's fees, just to make sure that they're not claiming it. I know, it's not on the table.
Okay, thank you very much. Thank you both. Gateway Overseas versus Sumac Tiles.
Good afternoon, Your Honors. Economic duress is the only reason that Gateway would have agreed to a massive reduction in the commissions that it was owed under the parties' written agreement signed by Sumac and whose validity is not disputed.
Why did Mr. Wah take so long? I mean, 2.5 years or something before he brought this claim of economic duress. I think he was understandably, if he was in China and was concerned, that's one thing. But once he returned to the United States, that was in 2015, I think, he still didn't bring this action.
Well, right. he continued to do business in China. This particular contract went until the end of 2017. Payments were still being made to his company until November of 2018. And he brought this lawsuit in May of 2018. So he didn't wait at all. He waited until the contract was completed because he didn't want to lose whatever pittance of the monies that he needed that Sumac was going to grant him. And it was at the end of the contract that he decided to come to me, come to get a lawyer, and we filed suit promptly. And the court below.
Counsel, you concede that he could have brought a breach of contract claim from the get-go, right? As soon as the commissions were reduced, couldn't he have sued the defendant and said, no, pay me my 5%?
Well, first, there's two things on that. One is the proper standard of economic duress, which I want to return to. But as a factual matter, he believed.
I'm just talking about pure, straight up breach of contract. Why couldn't he?
Well, he believed that he could not recover under a standard breach of contract case. Sumac had told him in that November 2015 meeting that he wouldn't win the case. If he won, he wouldn't collect. And that furthermore, because of Sumac's relationship with the Chinese authorities, they would assure that they would thwart all of his possible means of recovery, and that they would use every means possible to ensure that his business would be, in effect, destroyed, at least with respect to China. And he was afraid of that.
And none of that was in writing? You didn't have any of that in writing?
It all comes down to that November 20, I believe it was 15 meeting between the parties. And it's that meeting that really raises the issues of fact that, in our view, Justice Sherwood disregarded. In addition to, we believe he also applied the wrong standard of law. I mean,
my question was, there was nothing in writing.
There were emails back and forth between the parties constantly.
Right, solidifying the 1% that you had agreed to it, but nothing.
Well, even prior to that, the emails between the parties that are in the record go back to the unjustified, in our view, demands that Sumac was making, which first it was reduce it to 3%, then it was, at the November meeting, reduce it to 1%. And the emails back and forth were all whether or not Sumac was justified in making these demands of Sumac. And the court didn't analyze that at all. In order to prevail on a economic duress claim, a party to a contract, all they have to do is threaten to breach the agreement by unlawfully or improperly withholding performance. That's precisely what Sumac did in 2015 until November 2015. They insisted that for no justifiable reason, in our view, and that's the emails that I'm talking about, which went back and forth, they insisted that because that Sumac, Gateway reduce their commissions, even though Gateway did nothing wrong and there was no legal basis for those demands. In particular, with respect to their claim in the court below that they were justified in demanding that that Gateway accept a reduction in their commissions, they said that, for example, that it was because Robert Allen had withheld some payments for non-conforming goods. And as you'll see with respect to the emails, it's our position, and it was our position then, as reflected in those emails, that The inspection of those goods was not our responsibility. The ensuring of the quality of those goods was never our responsibility. And to guarantee the payments by Robert Allen also was never our responsibility. So these demands came, they were made out of whole cloth, and it was only because they knew that Gateway was in financial distress and that it had in effect lost control of the client, so that they were not free to go their own way, terminate the relationship with Sumac and hire another supplier. They were unable to do that, and Sumac was aware that they were unable to do that. They therefore made these unjustifiable demands, which in our view and in the view of the law, the standard of law is that if a party makes a demand to withhold performance under the contract and is not going to perform that contract unless the other party exceeds to these demands, that economic duress has been established. Now, the court below found other things. The court below found, for example, that Gateway did not have a separate other contract that it was in danger of breaching in the event that that it didn't exceed to the demands. But as we point out in our brief, there's no case, and the defendants cite no case, that imposes that kind of a standard, that requires that there be a separate and a contract before economic duress is established.
Thank you.
And the court also said that, as you started out with, they have to establish that there was the breach of contract claim that they could have brought in court would have been inadequate. So two things, Your Honor. First of all, that comes from a case called Austin. And in a case after Austin, 805 3rd Avenue, that the Court of Appeals decided subsequent to Austin, that requirement is not part of the economic duress standard. And in any event, I believe that we have met that standard because, as I said before, it was Gateway's view, and it was not explored in discovery or by the court, that it had no opportunity, that it was afraid to file a breach of contract suit because, as Sumac itself said, if you sue us, you're not going to win. If you win, you're not going to collect, and we're going to thwart every attempt of recovery. And we know the Chinese authorities, and they'll make sure that your business in China is destroyed.
Okay, thank you. Let's hear from Ms. Liu. You're still muted.
I'm so sorry. Thank you so much. So I want to respond to a few things. First of all, the issue about whether Gateway had adequate remedy at law. So Your Honor is correct that Gateway had adequate remedy at law because that's Austin instrument, which case says that the Court of Appeals said the ordinary remedy of an action for breach of contract would not be adequate. That's a requirement for establishing duress. And 805 3rd Avenue, cited by counsel, is in opposite because in that case, the Court of Appeals rejected the duress claim because the defendant had no duty to perform. So the court didn't have to go to whether actually there was adequate remedy at law. So now going back to whether Gateway had adequate remedy at law. So this is Gateway's claim is mainly or is purely about money. There was no threat of any breach of Gateway for any of its obligations to other side. Under Gateway's own theory, Gateway says all I had to do is to collect money on the payment from Robert Allen. So they could have brought the case in 2015. There was no reason, no excuse for them to wait till 2018. Now, so that's adequate remedy at law. And then threat by Sumac, I have to point out that the counsel was incorrect in alleging that Sumac made any allegation about its influence of a Chinese government or whatever the Chinese government is going to do to Gateway. There's no allegation. Even his client's own affidavit doesn't allege that. All his client alleges was, Gateway would not be able to win, and if they won, they would not be able to collect. That's the kind of ultimatum you see all the time in, negotiations. That doesn't actually stop Gateway from bringing this lawsuit in 2018. So that's the factual record I have to correct. And then in terms of the business interaction, I again have to correct the record because the business interaction between the parties ended in March 2017. So it's Gateway's argument that they were entitled to more payments after that. But from March 2017 to April 2018, Gateway did nothing. They were still completely silent with no objection to SUMAC or to the 2015 settlement. They just sat there doing nothing. And then also about the rating, I'm sorry. I will also point out that Your Honor is correct that there's nothing in writing to show any allegation made by SUMAC over Gateway in these negotiations. All the written record shows that before the 2015 settlement, Gateway actually protested about, SUMAC's claim about the dispute. But after 2015, the settlement, Gateway was completely silent. Not only that, they actually ratified the contract 18 times through commission invoices, pocketed all the money with no objection and no reservation. So on counsel's argument about justice, the second issue, basically, whether the lower court actually erred by limiting its holding to that the duress can only be exist when the threatened party is at risk of breaching an obligation and some other agreements. That is a red herring argument, because in Gateway's own opening brief, Gateway admitted by stating that the trial court rejected Gateway's duress argument on the ground that the dispute is for money and that there's no reason Gateway could not have sought relief on the court basis in 2015 or shortly after being paid on the reduced invoices. That's in Gateway's brief at page 9. So they admit that the court actually found that there was adequate remedy at law and Gateway was too late in bringing this action. Thank you, Your Honor. I'll be happy to take any questions.
Mr. Tokyo.
Yes, thank you.
Back to you.
Thank you, Your Honor. With respect to this issue about whether or not the Gateway delayed, I guess that issue goes towards whether or not there was a waiver somehow, because we filed this lawsuit well within the statute of limitations, and I explained before, even before payments stopped coming from SUMAC. And with respect to any delay and whether or not there was any waiver, the court below did not find that there was any waiver, that there was any unreasonable delay. And I think that raises issues of fact that certainly this court can't determine. If you're going to reverse on that ground and send it back to the lower court on the issue of waiver, I think it's up to the lower court after discovery, and if we finish discovery, at that point, I think we might discuss whether the delay was unreasonable and amounting to a waiver. And with respect to the adequate remedy of law, which I think is an important legal issue, I did address that in my opening remarks. I did refer the court to 805 3rd Avenue. The case might be distinguishable on the facts, but it sets forth a very clear standard of law, and that standard of law is different than the one in Austin. And by the way, in Austin, the law is also dicta, because in that case, the court did find duress, although it had a little bit of a different standard. I suggest I would invite the court to revisit that standard and affirm the 805 3rd Avenue standard that does not require for economic duress that there be an adequate remedy of law proven, even though we do believe that we've established the fact that Gateway did not have an adequate remedy of law, which is why we believe that economic duress applies.
Thank you.
Any other questions? Thank you, Your Honor.
Thank you, Your Honor.
Thank you both. Sitbon versus Robson. Sitbon Robson, I'm sorry, versus Robson or Robeson.
Yes. Appellant here, Your Honors. May I begin?
Yes, you may.
Thank you, Your Honors. May it please the court. The issue in this case is whether the court should reward a party who has concealed a substantial marital asset throughout the divorce case and allow that party to reap the fruits of his ill-gotten gain. When appellant discovered this asset, a respondent did not say, mea culpa, I forgot about that account. No, instead he actively concealed it, but argues to this court and argued to the lower court that he should keep it because his wife did not do enough to see through his deceptions. The respondent here worked diligently to conceal this asset. There were 3 net worth statements that he filed that were sworn to, and in all 3 of them, he did not disclose this account with ComputerShare. There's a statement of proposed disposition that he filed as well, in which he had to list all of his assets, both separate and marital, and he didn't list it there either. He was questioned at his deposition about having a potential asset there as well, and he said no, he doesn't. He actually has all the UBS, all of his Thomson Reuters stock was at UBS. And the fact of the matter is, the parties had a great deal of Thomson Reuters stock. The husband had been an executive at Thomson Reuters for many years. They had a UBS account that had roughly $800,000 of UBS stock. That account was known to both parties. It was in fact, it was divvied up by the parties after the trial of the financial trial that had been done in this case. It was only by happenstance after that trial that the appellant found out about this extra Thomson Reuters account at ComputerShare because she received a check in the mail. Now, a similar check had come in a few years earlier. When it did come in at that time, her lawyers said, "What is this for?" They questioned the husband and they served document demands on the husband for his accounts. No documents were produced about it. And when questioned at his deposition under oath, he said, "Oh, that's all the UBS stuff. That's all of the Thomson Reuters stock we have in the UBS." Turns out that was false. But judges, the best lies are those that have a veneer of truth. This one certainly had that veneer. It was plausible. The parties knew that there were $800,000 worth of UBS stock. When there was a small check that had come in.
Counsel, I just have to stop you. I just have to stop you and just ask you about the deposition, and then I'll let you wrap up. It seems you asked whoever it was, the attorney asked the question specifically about the Thomson Reuters stock, and it seems like he answered the question. He said, "Okay, we just had a long conversation about dividends being paid out. Okay. So this is administrative, presumably by ComputerShare for Thomson Reuters. It goes to the PEO box. My wife has access." I don't know why the attorney couldn't ask for all the details of that particular item then.
It's a very good question.
It was not something that wasn't known. It could have been followed up with asking for specifics. It clearly was known before the deposition. It could have been raised and asked for information to be brought at the deposition. I don't see why we're being asked now for the relief you're seeking.
Because the question actually, if you read his answer, it's very circular and it's very difficult to know what he's saying, except that he does reference.
So then you ask him to repeat it or clarify it. I don't really see.
And there were several back and forth of the parties, but at the end of the day, he specifically referenced that being part of the UBS account. And at that point, that sounded absolutely reasonable. There were $800,000 worth of stocks. This was a dividend. It was a small dividend. It was approximately $750. The statement that had come to my client in the mail, it actually has bold on it. It has Thomson Reuters on the left-hand side and ComputerShare on the right. It looks to be clearly Thomson Reuters related. They had almost all of their Thomson Reuters, she believed all of their Thomson Reuters account was at UBS. And the husband under oath says, yes, that's related to the UBS that we've got.
Well, I don't know. What I read in that answer is ComputerShare. In any case, you have a minute rebuttal.
And judges, there's so many opportunities where
counsel, I just said you have a minute rebuttal. I meant.
Oh, I'm sorry.
Yes. Hear from you then. Okay.
Thank you.
All right. The respondent.
Hello. Good afternoon. Yeah. The appellant's allegations of deliberate concealment of accounts are untruthful, and this ComputerShare is an account of which I was unaware. And at the lower court, it was found that she did not sustain her burden of proof, even though she had documented evidence on hand and in her sole possession since at least 2016. She freely admits she had these multiple records from ComputerShare in her possession before the trial, which were mailed to her address in my name, which she opened and in fact chose not to forward to me. So the appellant failed to provide and release those records she had in her possession. She could easily have performed discovery in a timely manner. She didn't ask more questions, per your last question to Mr. Advocate, that I honestly suggested, because that's what I believe, this is a computer share, sounds like a processing company that automatically issues, what's the word I'm looking for? The checks that she had received. She filed subpoenas on my employees. She had multiple banks for which she already had records. She knew the discovery process well. And as I understand it, case law says that the non-title spouse seeking a share of an asset does not have the burden of introducing that asset, does have that burden of introducing that asset at trial. She failed to complete due diligence with regards to discovery. She did not file any subpoenas, which she did for my employees and 14 other banks. I understand under CPLR 5015 from my prior attorney's statements that she is required to show why that evidence could not have been found prior to trial. She did not do that because she clearly did have the evidence prior to trial, which is why the lower court ruled as it did. And the appellant's own lawyers failed her. Mr. Advocate was not at that deposition. He is his third lawyer. She did not follow the appropriate process of discovery, and now she seeks the entire asset and all $100,000 in legal fees from Mr. Advocate from me. And I think, if anything, I've spent about that much money myself defending against an order to show cause, which was rejected, an appeal, which was rejected, a subsequent motion, which was rejected, and now this appeal. This is the same claim filed multiple times. So I don't think it's fair that the appellant should be allowed all these second bites at the apple.
Thank you. Mr. Advocate, 1 minute.
Brief rebuttal. First off, Your Honors, there was discovery that was sought on this material. It was never provided. There's a discovery notice. It's part of the record. There were never any computer share files or documents that were ever provided in response to that. Secondly, to go back to the issue of discovery was done, subpoenas were served on accounts that we knew about. In other words, we knew that there was if there was a Citibank account, we served subpoenas to make sure that we had something there. We didn't serve subpoenas on every financial institution in Canada, which was where computer share is, because we had no knowledge that there was such. In fact, in the answer in the deposition, he specifically said that the dividend that was paid is in the UBS account, meaning that it's a reference to the fact that the shares there are in the UBS account. That was demonstrably false. And although Mr. Robson says he didn't know about this, the fact is he concealed it at every opportunity. He could have said, I wasn't aware of it, and I'm going to provide you with your share now that we're aware of it. But he's taken an opposite tact. He said, it wasn't known to me. I didn't know about it, but I should keep it now. I should reap that windfall because it's under my name. And I do not believe that's correct. And that's not what the law is in this jurisdiction. Net worth statements are sacrosanct. Parties are swearing to something. Parties have to have transparency in order to do these divorces. And if you're going to reward someone for concealing an asset, I believe the court is going down a very dark hole. Thank you, Your Honors.
Thank you both. Last case for argument is Rodriguez versus 352-354 West 48th Street. Justice Mendez is recused from that case, so give him a minute to sign off while Justice Weber signs on. Justice Weber, are you there?
I am here.
Okay.
Okay.
Counsel?
Yes. Thank you, Your Honor. May it please the court, my name is Jonathan Landsman. I represent Neil Rodriguez. This court should reverse the order of the court below. There is substantial evidence of discrimination against Hispanic people at this HDFC.
But
ranging.
Counsel, isn't there ample evidence in the record that your client's application was denied for non-discriminatory reasons?
Well,
wasn't he asked several times to provide information on his income? Tax returns were never provided. I mean, not until I think the third request or the final request was, did he provide, I can't remember what they were, but evidence of his, I think his credit report.
Your Honor, I thank you for giving me the chance to clear this up. He did produce his tax returns by September 2010 sublet application, again in the December 2011 transfer application, and in the April 2012 transfer application. It's important to note that notwithstanding what the housing court found was his breach of the lease in remaining in the apartment as a subtenant or an occupant, in the March 30th, 2012 housing court order, the court nevertheless gave a post-judgment cure period. You have one more chance to submit your application to transfer. And in April 2012, he submitted.
So I'm sorry to interrupt, but as part of that transfer application, there's a review of income. Is there not? And in the papers they reviewed, they showed that he had I think a low credit score, but more importantly, I think that he had defaulted on the mortgage. So I think that was at least one of the bases.
Right. Well, I think they did give 4 reasons for denial, Your Honor.
Right.
But it's important to note that even if the board had one valid reason or more than one valid reason for denying the transfer application, if they were also motivated, at least in part, by racial discrimination, then under the New York City human rights law, he wins.
Right. And that's very broad, but every one of the Hispanic candidates, the Hispanic tenants said that there was no discrimination, and the one white candidate, the one white tenant or member of the board said that he had claimed that he was being discriminated by Hispanics, not that Hispanics were. I mean,
First of all, at their depositions, board members said one thing, but before the Division of Human Rights, they said another. And their statements before the Division of Human Rights were submitted into evidence without objection, and those are admissions of the party opponent.
I'm sorry, counsel, this is Justice Weber.
Yes, Your
Whose
Honor.
statements are you referring to before the Human Rights Commission? There was only one individual who I saw who was a white individual who also had issues with the board members. I did not see any of the testimony from other board members or anyone else that this was based upon any discrimination against your client because he was Hispanic. And I thought that even his family members stated that they had no information that this was based upon the fact that he was Hispanic.
Well, I didn't call his mother. I mean, if someone wants to call an 8-year-old mother to defeat a discrimination case, that's not particularly.
So I'm sorry, my
fair,
question is who other than this one white individual stated that the basis for his the basis for the board's rejecting his application was because he was Hispanic?
Sure, thank you, Your Honor. Board member Hector Zuniga told the Division of Human Rights that the board president favors Americans and that people who are considered more American or Europeans are treated better than other people. He said that in the statement before the Division of Human Rights. I believe it's 1158 to 1159 of the Record on Appeal, or 1655 and 1663. Also, board member Jorge Posada, who's Hispanic, gave similar statement before the HDFC. And Raymond Delgado, another longtime board member, told the Division of Human Rights that they interviewed people to live in the building, but they never approved Latin Americans. So that is all in the record. And I know you refer to Mr. Kaminsky as a white person who made an allegation that he was discriminated against. His claim was that he was discriminated against because he had children and he was white. Now, he made a claim under New York state law to the State Division of Human Rights. My client was not a party to that proceeding and is not bound by the State Division of Human Rights finding that there was no discrimination against the white person. What Kuzminski adds to this case is his sworn deposition testimony that he has heard Jordan Kale refer to the president, refer to a hit list of Hispanic shareholders who she wanted to evict. That she made a remark, this Spanish thing, it's just a bit too much. That's sworn testimony of Kuzminski, that she said that to him because she didn't like Hispanic people controlling the board. That Marcel Lutece, a white board member, thought the hit list was very hilarious, according to Mr. Kuzminski. His sworn testimony, the fact that he is admissible, especially to defeat summary judgment.
But didn't your client, his deposition testimony, his prior testimony, he stated that it was purely financial. He stated that it was based upon, I think his credit score rating was like 570 or something like that. There were numerous defaults, etc. During his deposition testimony, he claimed it was purely financial. And then it was only later on that all of a sudden he stated that now it was discriminatory. And this was based upon his affidavit. But all along, previously, he stated that it was purely financial.
And again, this is so important to have oral argument so that I could clear this up, because I realize the record is voluminous. December 2011, he gave housing court testimony. At the time, this was only related to the September 2010 sublet application, where he had made a request for permission to sublet, and the board said no, and we're going to evict you. So the case went to trial in December 2011. He was asked, he said that in April 2010, approximately, he spoke with board member Killian. Killian said, no matter what you do, you're not going to be approved. And yes, when I asked him, did Killian say why? My client said no. Fine. Then we get to the deposition in this case. My client did say that Quillian said that Jordan Kale wanted to, the board president, wanted to drive Hispanics out of the building. Now, I recognize
that. I think he didn't really have when he was asked to explain it further, he wasn't clear on that. I think he said it could be for numerous possibilities. It could be she didn't like Hispanics. It could be that she wanted to sell the apartment and get, and the board itself get the shares of the sale. It could be she was trying to clean up the co-op. He had no idea what it was. He didn't specifically say, yes, that's true. It's with regard to Hispanics.
That's fine. And then he also testified that on October 9th, 2012, which was 9 or 10 months after the housing court trial testimony. So this is a totally different conversation, that Quillian told him that, again, that eventually board members would want to push all Hispanic tenants out of the building.
And then Quillian says he didn't say that. He testifies under oath that he didn't say that.
And my client said he did, but so there's a disputed issue of fact.
And did your client also at some point in time claim that he was being discriminated against because his income, or he derived his income from his being his occupation at a gentleman's club, and he claimed discrimination based upon that?
Well, the complaint, you're correct. The complaint in this action alleges both, and we did not pursue that when we could not obtain evidence of that during discovery. So the complaint did not say just income. It said race and income. Race and source of income. When we could not establish evidence of the source of income, I did not put that in on the summary judgment papers. I stuck to the race based on the testimony of Mark Kuzminski, all of which, by the way, the DHR investigation in 2012 was after the housing court trial. So we could not have addressed this in the housing court trial. And it's just critical to remember that even if the board had a valid reason for denial, even if it had one valid reason, if they were motivated in part by discrimination, the New York City human rights law requires that plaintiff prevail or at least get to a trial. That's the Bennett decision from this court, Bennett versus Health Management Systems, 2011 case. So yes, there's a lot of contradictory testimony from all parties in this case. I mean, I tried to show in my brief on appeal how the defendants were inconsistent about everything. But the fact is, this is a low-income co-op. There's an income cap of $32,500 for single people. There are people with, the maintenance is $300 a month. This is not a Park Avenue co-op, and people are going to have credit issues. That doesn't mean when the housing court judge says.
What you're saying is you're asking them to ignore the standard that they have because it's a low-income building? No, you just said they have a standard, right? So
I'm sorry, I don't think I said they had a standard. If I did,
you said this is a $32,000.
No. Thank you, Judge. Again, thank you for raising the income issue. First, in 2010, they said he made too much, so we didn't put in an application to transfer. Then, as it turns out, he did make below that amount. So when we submitted the 2012 transfer application, his income qualified him. And in fact, if you look at the 4 reasons why they denied the application, which is at page 563 and 1474 of the record, they do not say anything about income. He did meet the income requirements. After all this back and forth, he did meet the income requirements. So,
thank you.
Thank you, Your Honor.
Ms. Aiello?
Yes. Good afternoon, Your Honors. May it please the court. My name is Jackie Aiello from Boyd Richards, respondent. I'd first like to address the issue of this mixed motive argument. The mixed motive argument is done away with by res judicata and collateral estoppel. So the appellate term, when the appellant had appealed the holdover determination, the appellate term had the authority and in fact did search the record in order to reach its decision. And in doing so, it responded to Mr. Rodriguez's claims that he made both in his appellate brief to the appellate term and also in a cross motion at the holdover at the lower level that may have been motivated by discrimination and not just simply financial reasons. The appellate term did away with this issue of mixed motive because the appellate term held that the reasons that the co-op, the HDFC denied the application was for legitimate business reasons and actually reiterated those that credit score, his default, the prior foreclosure, the fact that he legally subletted, he failed to pay maintenance, and at one point had incomplete applications, even though that was rectified. So the mixed motive question has already been resolved by the appellate term, and so this matter is thus barred by collateral estoppel. And I want to address the fact that even if I know that appellant argues that this issue is not before the appellate term. We don't agree. We believe that the appellant actually raised the issue of discrimination twice, and so the appellate term did raise this issue. However, with respect to the res judicata question, even if we assume, which we disagree with, but even if we assume that the appellate term did not answer the question of whether or not discrimination was a motive here, the appellant had the ability and could have raised the issue of whether he was denied, this application was denied based on discrimination at the holdover level and at the appellate term.
Counsel, this is Justice Weber. I'm looking at the appellate term, the decision of the appellate term. I don't see any mention of discrimination or mention of the defendant, the plaintiff's claims as to discrimination in the appellate term decision.
So the appellant's brief, the appellant's appellate brief to the appellate term mentioned that it was in part due to discrimination.
But the decision does not mention it. It just says it supports the court's determination in terms of the rejection of the application. It does not specifically mention claims as to discrimination.
Your Honor, I disagree in that the decision specifically says that the rejection was for legitimate reasons and then sets forth what those legitimate reasons were. So since Mr. Rodriguez addressed this question of discrimination in his appellate brief, had the appellate term been concerned that there could have been a mixed motive of discrimination, I don't believe that the decision would have held that the rejection was for legitimate reasons and then citing what those legitimate reasons were. That's on.
I understand your argument. I don't know whether that is sufficient, for you to argue that, it's res judicata. That's all.
Well, that argument goes to collateral estoppel in that it has been addressed and that the appellate term searched the record. It was at issue and was decided. But even if it was not.
Sorry, this is Justice Moulton. What inference should we draw from the housing court's statement when it declined to stay the eviction, and the plaintiff raised, the board, he said, the board discriminated against me from inception. The housing court then says, quote, to the extent plaintiff wishes to challenge the co-op's denial of the third transfer application, I added third, it must be done in Supreme Court. Now, does that mean that the housing court was kicking over the discrimination issue to a Supreme Court action?
Whether or not the housing court attempted to punt it to Supreme Court, Mr. Rodriguez just chose his own forum, and he brought that issue to the appellate term. He is stuck now with the forum that he chose, rather than saying, I'm not now satisfied with the appellate term's decision. Now I'm going to go to the Supreme Court and try again. He is stuck with the forum that he chose. Okay. I'm sorry. So just back to Judge Weber's point on the res judicata issue, I just do want to point out that even if we assume that it was not in fact litigated or it was not in fact decided by the appellate term, Mr. Rodriguez had the opportunity and could have addressed this issue of discrimination. He could have raised it as a defense at the housing court level and decided not to, and that would also bar him under res judicata, even if the claim is not barred under collateral estoppel. I do want to address a few other things that Mr. Landsman had addressed with respect to whether there's enough evidence here to find discrimination. The appellant identifies a slew of testimony that falls within one of three categories. The testimony is either irrelevant to Mr. Rodriguez's claims, for example, those who surmise that the board in general has disdain for Hispanics, or that they just don't like Hispanics, or they're driving Hispanics out of the building, but irrelevant to the issue of whether Mr. Rodriguez's application was denied for discriminatory purposes. It also, the testimony that the appellant relies on also falls into two other issues. One is that much of the testimony that was cited to is speculative, or it was conclusory. There was nothing that actually identified discriminatory motives for Mr. Rodriguez's application denial. And finally, the fact that Mr. Rodriguez, he points so heavily to Mr. Kosminski's testimony is baffling, as Mr. Kosminski is the one who went to the state division. He claimed, not only did he claim that he himself was discriminated against for being white, but he stated very specifically, and it's in the decision that's cited in our brief at page 10, claiming that Mr. Coolian was a racist against white people, that he made discriminatory comments about white people, and that the board actually favored Hispanics. He then came around and said, in support of Mr. Rodriguez, that everything he said in support of his claim for discrimination, not true. It was the exact opposite. The motion court in this case saw right through it and held that Mr. Kosminski's contradictory statements were not going to be given any weight. The same goes for Mr. Rodriguez's contradictory claims, where at the holdover proceeding, he testified not only that the board not only that the board had a financial motive for denying his application, but with respect to this discussion that he apparently had with Mr. Koulian, he says very explicitly at the holdover proceeding, I spoke to Mr. Koulian. He said your application is going to be denied. Mr. Landsman, his counsel, asked him, did he ever tell you why? He says no. If Mr. Rodriguez knew at the time that someone had told him that he was his application was denied because he was Hispanic, there is no reasonable explanation why Mr. Rodriguez would apparently forget that testimony and then forget that conversation, and then years later during his Supreme Court action, submit an affidavit which exactly contradicts what his holdover proceeding testimony was.
Thank you. Are there any questions from the bench? Any further questions? Okay, thank you. Mr. Landsman, you have 1 minute.
Thank you, Your Honor. The last argument really goes to weight. As to financial motive, yes, we did argue that, but that doesn't mean if there's a hit list to drive out Hispanic shareholders so that the HDFC could get the huge flip tax, that's both financial motive and illegal race discrimination. Second of all, as to res judicata, there's no compulsory counterclaim rule. We did not raise the issue of race discrimination in the appellate term. I refer you to page 24 to 26 of my reply brief. We specifically said we're proceeding with the Supreme Court action to deal with the denial of the April 2012 transfer application. The only mention of the word discrimination was with respect to 2 Hispanic shareholders who are allowed, who tried to live in apartments after their relative died. One of them was Elena Delgado. One of them was Neil Rodriguez. The board let Delgado stay in her deceased mother's apartment. The board did not let Rodriguez stay in his deceased grandmother's apartment. So we said in the appellate term brief that this was discriminatory selective enforcement. But that was as to the sublet application. This was not as to the denial of the transfer application, because we had not done discovery about the denial of the transfer application until the Supreme Court action. And as Justice Moulton correctly pointed out, when we went to housing court in June of 2012, we specifically told the court, we're going to commence a plenary action. We want full discovery. And would you give us a stay of eviction so we could commence the Supreme Court action?
Thank you, counsel. I've given you over a minute.
I appreciate your attention to the detail of this case. I really do. It's a voluminous record. And thank you.
You're welcome. Thank you both. This concludes oral argument for today. Court is adjourned.